All right, good morning. We'll start through the call of the docket. I think this is the same. On page 1 of the docket, 14625B, State versus Angela Baker.
That is my case. Ms. Baker is here. I had a chance to speak to her and have a few minutes to talk with her.
All right. The next would be 15063, State versus Ethan James Beard.
That would be for a hearing, Judge, so if we can set all that.
All right. One 5035, State versus John Isaac Brewer. Mr. Lockhart.
He was
Pardon?
somewhere this morning.
Cheatham County.
Besides here.
Live in Cheatham County. Let's take a call.
14555, State versus Hayden Grant Chapel. Mr. Patrick Stacy.
Your Honor, that's mine. If we put that on second call, I think we have to do it.
I have to draw the paperwork.
15208, State versus Avon E. Curtis. Mr. Flanagan's case.
I have not heard from Ms. Flanagan this morning.
I have not.
I'll text him.
Get you to find out.
Yes, sir.
Have said, Mr. Curtis, we'll find out where your lawyer is. So. 15113, State versus James Tyler Dabbs, public defender.
Judge, yes, Mr. Dabbs is in custody, so he's being brought over. That would also be for a hearing.
All right. 14639, State versus Clifton A. Damesworth. Damesworth, you have filed a motion asking that the court order that you have an unrestricted driver's license.
So,
Yeah, you understand I don't have any control over that. That's the Department of Safety. That's the one that issues the restricted or unrestricted license.
Well, these are the process that I was told to go through, so I was just trying to put in my footwork.
Well, McLeod, this was your case originally back in 2024.
Yes, Judge.
Based on the DUI,
Well, that's what I'm looking for. Why is your license revoked to begin with?
It's for non-payment of court costs. I reached out to the Department of Safety and they said that you would have to pay it in full or have it restricted. Is what they told me. I don't know.
So your license was revoked, apparently the clerk tells me from, because you have not paid your fines and costs in this case, and that included, I think, a fairly significant restitution. And because you had not paid that restitution, the restitution alone was $4,725 and $11,066 to Sandra Forrester. Because you had not paid that, the Department of Safety revoked your license. And under the current rules, the only way you can get a license of any kind is to make a payment arrangement with the clerk in order to then have the Department of Safety approve that payment arrangement and issue you a restricted license. I don't have any basis that I can see to simply say, well, you don't have to have a restricted license, because to do that, I would have to more or less suspend your restitution, which I'm not going to do. So I don't know, you may want to consult a private attorney to see if you can get some advice about what the next step would be. But as far as your motion asking that the court grant you an restricted license, I am denying that request, because I don't think it's within my power.
Okay, so is the restricted, I need to come down and
The form that I gave you, that's the restrictions.
Mr. Flanagan is coming in on the Zoom link, so let me see if we can ask him to unmute.
Can you hear me?
Hear you. Where are you?
I'm down here next to the federal courthouse.
Okay. Well, you had several cases that were reset for today, including
Yes, sir.
one we've already called. What is your intent regarding those cases?
Well, I can go through them, Judge, if you're ready.
Well, I'm ready. We got
All right.
Avon E. Curtis who's here in the courtroom.
Calvin Klein, no, not Calvin, Kansas Klein. That's the case that there's a civil case going on, and we're waiting to see if that gets resolved. So we don't need to set it for trial just yet. I think
Right,
General
you're talking
McLeod.
On page 6, can you hear me okay, Mr. Flanagan?
I can hear you, Judge.
All right, so we're referring to Russell Kansas Klein on page
Yes.
6 of the
Yes.
docket. And you're saying that you need another status day?
We do. There's the case is like 100 years old. I understand that. But there's a big civil case that once that's resolved, and I think General McLeod will agree with this, we can probably settle this. So,
You want to put it on that October date?
yes, sir.
October the 6th. All right.
Judge, I've
We
also,
have a-
go ahead. I'm sorry.
That's right. Well, one of your clients was here, Avon Curtis.
Right. And that does not need to be set for trial yet. That is a domestic, but I'll defer to the state on that. But
General McLeod.
It's a new case, Judge. I'm okay with putting it for status. Oh, it's this.
All right, we're going to move that to October the 6th as well.
yes, sir.
All right, what's your next case?
The next one would be Mr. Stanfield. I got appointed on that case. He's in custody, Judge. I was hoping to see him yesterday, but we didn't get out of Judge Wallace's court till 6:45 last night. So I haven't been to the jail to talk to this gentleman with the offer. So I need more time.
Well, is there any reason it can't be set for next month in front of who's your next judge? Judge
Absolutely.
Wallace?
Sure.
If you just need an opportunity to resolve it.
Yes, absolutely. I just need to get down there and speak with him, but I got tied up yesterday and then couldn't get
What's
there.
your next criminal docket for that?
June 14th, good.
Pardon?
Or July 14th.
July 14th?
Yes, sir.
All right, July 14th.
And I think the only other one I have is Jessica Wallace. And I don't know if she's present in the courtroom or not.
President in the courtroom.
Well, I'm not sure what to do with that case. It probably needs to be set for trial, but if the state prefers another status date, I'm okay with that. But
General, this is your case.
Well, Judge, I think Your Honor.
Why don't you come? He can't hear you unless you're at the microphone. So.
I was just going to say, I think Your Honor had previously set this for a final status date.
I did.
So I'm okay with setting it for trial because I have committed a plea offer and I just don't know what else I can do. I've talked to the victims and we are where we are.
and she is not going to plead, so it needs to be set for trial.
All right, well, we'll find you a trial date then. I think we're setting them in February now, is that right?
That might be better, maybe.
I don't remember what you said in October, Judge.
Is October full?
There was
I
some
can't remember.
there was some availability at the end of October. I think it's the 23rd.
28th of October, we have criminal trials on the 28th, 29th.
28th and 29th. I'm good with either day, Judge.
How about the 28th of October?
That's a good day for me, Judge.
All right, set for trial 28th of October. Miss Wallace, you'll need to make sure you stay in touch with your lawyer. It's for trial in October, okay? All right, thank you. Here we go. Got everything we got, Flanagan?
That concludes my cases, Judge.
All right. Then we
Thank you.
will allow you to leave our meeting. Thank you.
Thank you.
All right.
I'm going to speak to the doctor.
Pardon?
I was asking, Mr. Lynn's here from TDOC. Mr. Baker emailed yesterday, said he was in Charlotte in depositions this morning and would be here at some point, but he didn't mind if we reset it because we did have a global settlement offer, and I don't know how much time he's had to talk to Mr. Lynn. Not trying to talk to
When
Mr.
does he
Lynn.
want to reset it? October?
Yeah, I'm just what his email said yesterday. So TDOC's been here since early this morning, Mr. Lynn, and I don't know when or if Mr. Baker will be here. He said something about resetting it to try to talk to Mr. Baker or Mr. Lynn about all that. So I just brought that up, of course, attention in case you want to get TDOC out of here or have him sit here.
All right, well, we'll reset it for October due to Mr. Baker's not being available because he decided to do a deposition instead of coming to court, so
Just put it on 10-6.
10-6.
Judge, just for Madam Clerk and for TDOC, if we settle that, I think we could get another date. But he's got a motion for new trial pending. That's kind of what's
That's
here.
why it's locked in with me, because he has a
Right.
motion for a trial that I have to be the one to hear, so.
I'm just asking for TDOC, I guess. Do we want to set it at 1 on the 6th? So they don't.
Let's set it for 1 o'clock on the 6th of October.
Thank you.
Docket number 15087, State versus Brian Lee Davis.
I spoke to Mr. Roger Waiting about that one, and I believe we just need to get the trial date, probably in February.
January, or who is the trial judge? It'll be February.
Yes, that's.
Judge, you already got Heman, first degree murder, and February.
No,
FYI.
we have the State versus Human Vehicular Homicide stuff for February the 10th, 11th, and 12th. We have the 16th, 17th, 18th, and 19th for the State versus William Hall, first degree murder.
Yes.
And then we have State versus Robert Donovan, aggravated sexual battery stuff for the 24th and 25th.
Which is Mr. Wayne as well.
And so do you want to set it on the, if we don't do February, then we're talking June, I guess. You want to set it for June?
That's okay, Judge. That's fine.
It's not really okay because it's a year away, but
I would back it up if they were behind one of the others.
I'm sorry.
We could back it up in February, maybe behind what.
I don't really care. I just would rather it not. I mean, we can set it for the 20. Is it a 1-day trial?
It
this
could go
is-
into 2 days, right?
Brian, it could go into 2 days.
We know Mr. Waymack's available on the 24th, 25th anyway, for the other case.
You want to just back it up on the 24th and 25th?
If
And
that's okay with you, Honor.
it's fine with me. We'll put it on the 24th. It'll be February the 24th, second behind the State versus Robert Donovan.
Thank you, Jim.
And we have Samantha Lynn Garner, public defender.
Judge, I think that should be for police. She's in custody and will need to be brought over.
All right, we'll need her brought over. One for, we have at the jail, I don't know if we have, at the jail, you have some folks that I can take care of.
Yes, Your Honor. We have Glenn Goodrum on page 5.
For arraignment. Goodrum, you're here to be arraigned on the charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you? It's alleged that you were placed on probation on or about December the 13th, 2021 for a period of 3 years for possession of methamphetamine with intent. And it's alleged that you have violated your rule 1 of your probation because you were convicted for simple possession. And it's alleged that you should be violated. So I'm going to appoint the public defender to represent you. I'm handing a copy of that affidavit to your lawyer here in the courtroom.
Enter plea not guilty, Your Honor.
Plea of not guilty is entered, and we'll set it for next month on violation of probation day, which is
July the 26th.
July 26th. Is that correct?
July 28th.
28th. All right, July 28th.
Get a bond set.
Pardon?
Try to get a bond on this.
Well, your lawyer needs to talk with you about that. We're not going to deal with a bond today. He'll have to file them. It's not necessarily automatic that you can get a bond on a probation violation, but your lawyer will talk with you about it, and if it's appropriate, he'll file the appropriate motion. All right, thank you. Who else do we have at the jail?
Carlos Quillen, page 10.
Your Honor, if we can set Mr. Quillen's case at 7/14 on docket call next month, I think it's 7/14. We may have a resolution. He was applying to treatment, possibly, so we're trying to work it out.
Quillen, your lawyer's asked to move your case to July 14th to try to see if they can get your case resolved by some sort of treatment agreement. So we'll have a different judge, but you'll see you then.
Yes, sir. Thank you. Have a nice day.
Thank you.
We have Jennifer Renee Smith, page 11 of the docket.
Miss Lowe represents Miss Smith. That's a motion to revoke bond. Miss Lowe, we were here for docket call. We set that for today. She indicated that she had to be in Houston County this morning and wasn't sure what time she'd be able to get here, but we put it on just in case she could get here. So for now, it just be on second call.
All right, we'll put it on second calls until Miss Lowe can arrive.
William Scott Burns, he's on the add-on.
And Mr. Lockhart is the attorney. Burns, you're here. Let me see that. According to the docket, you are here on a charge of attempted first-degree murder, aggravated kidnapping, aggravated assault, and domestic assault. And your lawyer is Mr. Lockhart. Was this for status today?
Yes, Judge. My understanding is Mr. Burns, he'd been committed. and he was sent back and deemed competent. And I just wanted to put him on the docket to avoid him falling through the cracks. I
Right.
spoke with Mr. Locker about it. He's filed a motion on it yesterday. So
He's what?
he has filed another motion on this yesterday. I think he wants him to be evaluated again. So we may need Mr. Locker here for that.
Mr. Lockhart is not here yet, so we're gonna put you on the second call so we can determine what needs to be done in your case. So we'll come back to you. We'll probably bring you over so we can find out what Mr. Lockhart's gonna do.
I have not received a notice. I don't know if he says it's late.
Anybody else at the jail?
No, Your Honor, we're just gonna bring them all up, I guess.
All right.
Thank you.
We'll go back to.
Your Honor, on Hayden Chapel, myself and Mr. Patrick talked about that one, and we would ask if Your Honor is okay to put that on July 14th, bring the plea on that day.
Right, on page 2 of the docket, State versus Hayden Grant Chapel, we're gonna move to July 14th. Right.
Thank you.
I'm skipping over the jail cases that I'm told are but it's supposed to be brought. Mr. Patrick, you have Robin Haskins on page 5 of the docket.
I do, Your Honor. There's a co-defendant I represent as well.
Jeffrey Penix.
On page 10. I've spoken with the DA on this and reset for status on this. I think we're making progress on it.
All right, so are you asking me to set another status day?
DA and I are in agreement on this. Yes.
And are we setting it?
Your Honor, we could put it on 10-6, if it's okay.
That's fine by me.
October the 6th.
For both of them, Judge, correct?
Yeah, that's right.
I only have one other left, and it's sort of care to take it out. Short matter.
Who is it?
Dylan Scott Neely.
On page 8.
Page 8, and then continue to page 9. Mr. Neely, Your Honor, I think we're making progress on that. And request that be said, that's fine with the DA to 10-6 as well.
That's fine, Judge. I have conveyed a plea offer, and he countered, and I rejected the counter. So I think he just needs to speak with his clients as well.
The final plea day will be October the 6th. If it's not resolved on that day, we'll set a trial date.
Thanks.
Thank you, Your Honor. That's all I have.
One 15118 State versus James J. Jessel, public defender.
Yes, Judge. I think where we're at on that one is the state made an offer, we had made a counter offer, and I think the state is waiting to hear back. I think the DA, General McLeod, had called the victim to discuss that counter with the victim and left a voicemail, and I don't believe she's heard back, but I'll let her speak to that. So I was thinking if we could set it maybe on 7/14, if that's
I should
okay.
have let me speak.
My apologies.
Your Honor, I did want to confirm, I did reach out to the victim. I called, left a voicemail, and he hasn't responded yet. He has been in contact with me before, so I don't know why he wouldn't. Maybe he just hadn't had a chance to call me. It's been since our last court date, so he may just need to follow up with me in his more time.
All right, July 14th.
Thank you, Judge.
13678 State versus Russell Klein. We dealt with that one. 15122, State versus Tanya Lee Mathis. Ms. Mathis, I know that you're requesting, according to the docket, is the motion to remit your fines and costs, but in your actual typewritten request, you're stating that you're seeking assistance with your fees, but then you're facing challenges with travel requirements, and you've been asked to travel to Nashville 5 days a week. Is that regarding your treatment? It doesn't have anything to do with your probation, correct?
I didn't pay probation off.
Okay.
Now I was gonna see if I can get on probation too. So I can't have all of it. Stretch the bird.
When you entered your plea back in 2025 or last year, you were placed on 3 years supervised judicial diversion, which means that if you stayed out of trouble, you could have it expunged if you successfully completed it. But it was also required that you pass all drug screens as a condition of diversion, 0 tolerance for failed drug screen. Now you are undergoing, obviously, treatment for breast cancer, and I'm sorry that you're having to deal with that. Does the state have any position about this situation? I think it was yours, Mr. Collins. Who is the probation officer?
Was her officer, but she's now
So she's in a call-in basis? Right. So if you're on a call-in basis, already you're not having to report. And what else? I don't know that I can do anything else. I can't just say 3 years, you're just going about your business and you're not being supervised at all. But if you're on a call-in basis, then that's about as liberal as we can
The
get.
only time I got is like if I'm in a hospital or something, I can't call in. I got surgery and everything coming up.
Well, I would
And
think
that's
that
gonna violate my probation.
I would think that what we can do is to notify your probation. Who is your probation officer now?
It's Officer Naim too.
All right, I know Officer Naim too, and I think that if this court advises that all you have to do is if you're in the hospital, you just notify your probation officer you're in the hospital, and that'll resolve the issue. So I don't think you'll have any problems with her. You just got to let her know what you're going through, and everybody will understand that, and I'll understand it, and Officer Naim too, who I deal with on a regular basis, will follow my instructions to allow you to avoid having to telephone report if you're undergoing treatment.
Okay, what about the way to advise?
Based on your hospitalization, I will remit your fines and any remaining court costs that you may have. So, thank you. Do you want this copy back, or is this one that we can have? We'll mark it file this part of that. 14293 State versus Clinton Lee Mosley. Mr. Mosley files.
Actually not here this morning. I just spoke to his wife a little bit ago. He's in an unexpected surgery for St. Thomas.
Okay. This says that he has filed a motion to remit his fines and costs due to being on hospice.
Yes, sir. He's on hospice care as of the last couple of months. They've been in really good contact with me and keeping me updated.
Well, I'm gonna grant his motion to remit his fines and costs based on the fact that he's in hospice care, whether he's here or not. So I'm granting his request. One 4430 State versus Joshua O. Prentice.
Prentice is here, Judge. That's mine. So, Judge, Mr. Prentice was here, I think, on a VOP or a VOCC. He had entered a conditional plea where he was going to be furloughed to treatment at the Mosaic Center and then reinstated upon successful completion. I'm pleased to say that I do have a letter from them. I'm pleased to say that he has successfully completed long-term treatment at the Mosaic Center. And I think that it was just set for a review today to make sure he had done that. I believe the court file already has a plea petition from him, so I don't know that another one would be necessary. I could be wrong.
The order that was probation revocation order entered states that he would admit his violation of probation, waive a hearing, be furloughed to treatment at the Mosaic Center. If he was successful, he would be reinstated. And if not successful, he would be revoked to serve. So upon his having successfully completed his treatment, I'll order that he be reinstated to probation.
Thank you, Judge.
Thank you. He needs to make sure he sees his probation. 14438 State versus Kevin O'Brien Ralston. Ralston, you are here today on a review of your payment status, and basically there was a violation of probation served on you in May of last year, and we've been reviewing your payments. You paid a total of $120 on the balance of $5,608. Your last payment was June 1st. Why are you not paying more? Why are you not able to pay more?
They set me up for $20 a month because I'm still healing from surgery. I can't work right now. So I'm still having to go to the doctors and everything.
What was your surgery for?
I had a tumor removed off the brain.
Well, part of this is restitution of $5,000, and for that reason, I cannot remit restitution. That's something you're going to have to pay. We'll set another review date for you in October the 6th, and you need to make sure that you're making those payments between now and then. Okay. All right, October 6th. 14538 State versus Michael K. Slayton. You were originally replaced on probation. You were sentenced to 8 years in Tennessee Department of Corrections and placed on probation April of 2022. and that you had violated your probation, admitted violating your probation back in October of 2022, and you were ordered to serve the sentence of 8 years in the Department of Corrections, with it being suspended to probation on time served. Now you have filed a pro se motion to have a drug test removed and want to get on a call-in status. You've completed a 50+ drug test without a positive drug screen, and you're asking basically to be allowed to remove the drug test requirement.
Yes, Your Honor, my probation officer has been pushing for this.
Your probation officer, what?
He's been pushing me to do this. So
Pushing you. Who is your probation officer?
Mr. Lutz. He's obviously not here today.
Well, it was part of the condition of the plea that you entered was you would undergo an alcohol and drug assessment, follow all treatment recommendations, have regular random drug screens during your entire sentence. Special condition of your probation was a failure to comply with the alcohol and drug assessment, or a failed drug screen was a zero tolerance probation violation. State have a position on this?
I don't know whose it is, but if it was a condition of his plea, our argument would be that the condition of his plea, and if it's gonna be changed, you'd have to go in front of the judge for a hearing to alter his plea.
Well, in my opinion, basically that was the condition of the agreement that was entered back in 2022, and you're halfway through your sentence. But I can only tell you that as far as this court is concerned, that was the deal. That was the deal you made to avoid going to prison. So you're being held to that deal. You'll have to continue.
Correct.
All right. Thank you. And then we have the State versus Semra, Christine Triplett, public defender.
Or if we can second call that one, I think that's gonna be for hearing, but it may get recorded. I was thinking.
We're gonna go through, Mr. Hooper, you have some matters we can take up.
Yes, Your Honor. This, triplet.
This is a VOP, docket number 15007. Got an agreement where Ms. Triplett will admit that she's in violation of probation, she'll be revoked. She'll serve 30 days on weekends, and then she'll be reinstated to probation.
All right, Ms. Triplett, raise your right hand, let's place you under oath.
You solemnly swear or affirm shall the whole truth and nothing but the truth to help you God?
State your full name for the record.
Summer Christine.
Ms. Triplett, you're here on a violation of probation. I want to make sure you understand your rights. You understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation. You understand that you would have the right to have a lawyer and have one appointed if you cannot afford your own. And we've done that with a public defender. You understand that?
Yes.
You understand that at that hearing, if I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by entering this plea, you're waiving your right to that hearing of that appeal. All I'm going to do is approve what you and your lawyer have worked out. You understand everything I've explained to you? You want to plead guilty according to this agreement. And upon your plea of guilty, I find you guilty, or that you be revoked and serve 30 days in jail on the weekends, and thereafter you'd be reinstated to probation. Okay? All right, good luck to you.
And Your Honor, she will start her weekends next weekend
All
on the
right,
10th.
start them on next weekend.
She's going to transfer.
This coming weekend, which is July the 4th weekend.
The next weekend, Your Honor.
Thank you, sir.
All right.
Thank you, Your Honor.
Who else do you have, Mr. Hooper?
Miss Samuel Gregory.
I'm sorry, who was it?
Samuel Gregory.
Mr. Plea, Your Honor. He's on page 5 to 12, Your Honor. Now, this is he's got two different, actually, Your Honor, I gave you the wrong sheet there, sorry. Look at that as well. My apologies. Mr. Gregory's got two indictments, docket numbers 15263 and 15264. Docket number 15263, it is a 7-count indictment. In count 1, he is charged with possession of methamphetamine, a B felony. He'll receive 10 years in Tennessee Department of Corrections. As a range 1 offender, that'll be suspended to community corrections. He must complete 1 year of synergy as a condition of his community corrections. He'll remain in custody until he's picked up, be taken to synergy by a member of the drug court or other approved transportation, pay a $2,000 fine and cost. Count 2 is evading arrest. It's a D felony, 2 years TDOC range 1, suspended to community corrections, consecutive to count 1. Again, he must complete the year. Synergy is a condition of community corrections, and he will remain in custody until he's picked up. Fine, $2,000 fine and cost. Count 3 and 4 nollie. Count 5 is paraphernalia, 1129, suspended to community corrections, concurrent to count 1, a $150 fine and cost. Same conditions as far as synergy and drug court. Transportation, count 6 and 7 are nollie. He would forfeit any and all seized evidence to the Humphreys County Sheriff's Office, and he will receive credit for time served from March the 31st of 2026 to 6/30 of 2026 on count 1. Docket number 15264 is a 3-count indictment. Count 1 is simple possession, 1129, suspended to community corrections, concurrent to 15263. Count 1 is $750 fine and cost. He'll have the same conditions as far as completing synergy and staying in custody until picked up. Counts 2 and 3 are nollie. He'll forfeit any and all evidence seized to the Humphreys County Sheriff's Office. And again, this is a 12-year community corrections sentence.
All right, have we placed him, Mr. Gregory, raise your right hand, let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall give in this case is the whole truth and nothing but the truth, so help you God?
Thank you. State your full name for the record.
Samuel Gregory.
Mr. Gregory, you're here on a multi-count, two different indictments, multi-count indictments. You heard what the state says your agreement is, but have you seen or been shown a copy of those charges and talked them over with Mr. Hooper and you, and he discussed the range of punishment you're facing as well as any possible defenses you might have?
Yes.
Well, it's indicated that you want to enter a plea of no contest. You understand that means you're not going to admit anything that you might have done, but you're not going to contest the state's evidence when they tell me what their evidence will be. And that evidence will be used by me to find you guilty according to this agreement. You understand that?
Yes.
You understand, however, that you have a right to plead not guilty to all charges and have a speedy and public trial by jury. You understand that if you went to trial, you'd be entitled to have an attorney and to have one appointed if you cannot afford your own, which we've done with a public defender.
Yes.
You understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses. That you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
You understand that at trial, you and Mr. Hooper could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena.
Yes.
You understand you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand that at trial, if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal, and all I'm going to do is to approve what your lawyer has worked out for you.
Yes.
But you understand that's going to result in a number of convictions, and those convictions are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You understand everything I've explained to you. You want to plead no contest according to this agreement.
Yes.
Is your decision to plead no contest today voluntary?
It is.
Anybody forcing you to do this against your will?
No, sir.
You're not being forced to do this.
No, sir.
You understand I cannot accept a plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty. I want you to step aside and let the state come to the podium and tell me what their evidence would be if this case went to trial.
This has gone to trial on docket number 15263. The state was expected to show that on March the 31st, 2026, Deputy Jacob Brooks with the Humphreys County Sheriff's Office attempted a traffic stop on a silver Dodge Charger. The Charger came to a stop but failed to put the vehicle in park. And as Deputy Brooks got out of his vehicle to approach the stopped Charger, the Charger took off. They went through parts of Humphreys County through 13 South, Old Highway 13 South, reaching speeds upwards of 100 miles an hour. At some point, the car got onto the interstate, got off in Hickman County, and eventually crashed. The driver got out and then eventually was apprehended after a short foot pursuit. It was Mr. Gregory was the driver. A search of the vehicle yielded 6.5 grams of what Mr. Gregory admitted was methamphetamine, and a glass pipe was also located inside the vehicle. In docket number 15264, state was expected to show on February the 4th, 2026, Caleb Elliott pulled over a car with a headlight on Highway 70 with a headlight out in the intersection of Powers, stopped the vehicle, and during the interaction, driver, so like it was Mr. Gregory, observed a bottle of liquor that was open during probable cause search, found some Suboxone pills, and an unlabeled bottle along with residue that he used, admitted he used to smoke methamphetamine, in the scale he used, admitted to use to weigh drugs.
But I'm not asking that you agree with the accuracy of those facts, but you understand that's what the state's evidence will be if you went to trial.
Yes, sir.
So what you plead according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes,
I feel like Mr. Hooper's done a good job of representing you confidently.
Yes.
Mr. Hooper, do you know of any reason you should not enter this plea?
No, Your Honor.
Anything further from the state?
No, sir, Your Honor.
Then Samuel Gregory, in docket number 15263, upon your plea of no contest to count one, I find you guilty of a Class B felony, sentence you to 10 years in the Tennessee Department of Corrections as a range 1 offender that will be suspended to community corrections. You must complete as a condition of your sentence a 1-year program at the Synergy Rehabilitation, and that will be a condition of your community corrections. You must remain in custody until such time as you're picked up to be taken to Synergy by a member of the drug court or another approved transportation. You ordered to pay a $2,000 fine and costs. Count 2, evading arrest, you're found guilty, sentenced to 2 years in Tennessee Department of Corrections as a range 1 offender, suspended to community corrections consecutive to count 1. You must also complete that 1-year synergy program as a condition of that sentence. You will remain in custody as set forth before, and you're ordered to pay a $2,000 fine and costs. Counts 3 and 4 are dismissed as a part of the agreement. Count 5, you're found guilty of paraphernalia, sentenced to 11 months and 29 days, suspended to community corrections concurrent with count 1, ordered to pay a $150 fine and costs. Counts 6 and 7 are nollied as a part of the agreement. You'll get credit for time served as set forth on this document, and all evidence seized is forfeited to the Humphreys County Sheriff's Department. This is an effective 12-year sentence for community correction. In docket number 15264, you're found guilty of simple possession, sentenced to 11 months and 29 days in the county jail. That will be concurrent to the prior case. You're ordered to pay a $750 fine and costs. Again, this is all the same conditions regarding your rehabilitation, and at Synergy will be applicable to that case as well. Credit for time served as well. That's the judge of the court. He's remanded to the jail until such time as he's picked up by drug court or some other person.
Your Honor, just of course where he has to go to Dickson County to resolve an issue there. He will go to Synergy on July 9th.
All right. Good luck to you. Mr. Hooper, you have any others?
No, Your Honor.
Sensing, or Mr. Sanders, do you have anything I can dispose of? Okay, we'll take you up then.
Michael Odom, Your Honor. Police sheets are in the files.
All right, Mr. Odom has a number of different cases. I've been handed docket number 14. Let's start with this. We have a violation of probation, and then we have docket number 14982, which is apparently an assault on the first responder and aggravated assault. And then in 15099, he was charged with assault on a law enforcement officer, assault, aggravated assault. I've been handed documents indicating also in document number 15154, he is charged with vandalism and assault on the first responder. Now, I've been handed all of these documents. You want me to state on the record what the agreement is? Is on this probation violation to revoke to serve with credit for time served. We'll start with that one. Mr. Odom, raise your right hand and let's place you under oath.
Solemnly swear or affirm that the testimony in this case shall be the truth, the whole truth, nothing but the truth, to help you God.
Yes, I do.
State your full name for the record.
Michael Brandon Odom.
Mr. Odom, I'm dealing with your violation of probation first because there's a different standard the way we handle it. You understand that you have a right to plead not guilty to that charge and have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation.
Yes, sir.
You understand if we had that hearing, you would have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to that hearing and to that appeal. All I'm going to do is order that you be revoked to serve the rebalance of your sentence with credit for time served.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
You want to waive your right to that hearing on your violation of probation and enter your plea according to that understanding.
Yes, sir.
And I find you guilty, or that you be revoked to serve your sentence with credit for time served. And that shows that it's from credit for time served is from May 29th of 2024 to present. All right. Now, on docket number 14982, it's been indicated that you're going to be entering a plea to an amended charge of simple assault. Receive a sentence of 11 months and 29 days to serve, in order to pay the court costs. Count 3, 1129 to serve concurrent. Count 4 also would be 11 months to 29 days to serve concurrently. So those would be 3 misdemeanor offenses that you would serve concurrently with one another. Do you understand that?
I thought the agreement was consecutive. I just wanted to double check that.
There are some consecutive charges later in the
We
agreement.
haven't gotten to those
For
yet.
purposes of this.
In Docket number 15099, it's been indicated that you're going to be entering a plea to assault on a first responder to serve 1 year in the Tennessee Department of Corrections in order to pay a $10,000 fine cost that would be consecutive to 14982, which is your probation right. I'm sorry. That would be, and count 2 would be amended to misdemeanor assault, 1129 to serve, concurrent to count 1, consecutive to the prior case. Count 3 is knowledge. Count 4, 3 years to serve in the Department of Corrections. That would be concurrent to count 1, consecutive to 14982. And count 5, vandalism, knowledge, but you have to pay restitution of $590 to the county jail. And count 6, vandalism and knowledge. Count 7, assault on the first responder. You ordered to pay 1 year to serve 1 year in the Department of Corrections. That will be concurrent to count 1. Count 8 will be amended to simple assault. You will serve 1129. That will be concurrent to count 1. Count 9 is amended to simple assault, 1129, concurrent to count 1. Count 10 is amended to simple assault, and a misdemeanor would be 1129 to serve, concurrent to count 1. All of those are consecutive to 14982. And I have 15154. I've lost the sheet on that one. Count 1, vandalism would be knowledge. Count 2 would be amended to a simple assault, 1129, to the Department of Corrections, consecutive to 15099. And count 3 is assault on the first responder, 1 year to serve in the Department of Corrections, $10,000 fine and cost, concurrent to count 2, but consecutive to 15099. So you want to tell me exactly what the conglomerate total sentence that he's receiving is?
Yes, Your Honor. On the VOP, that's obviously a revoked to serve a 5-year sentence. And the cases that the court just recited, those 3 separate docket numbers, the effective sentence in all of those cases combined is 5 additional years consecutive to the violation of probation.
All right. Mr. Odom, you've been previously sworn, so I need to make sure you understand your rights in these cases. Do you understand what you're charged with in each of these cases? And have you and Mr. Sanders been able to go over those charges, talk about the range of punishment you're facing, as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty to these charges. Do you understand that you have a right to plead not guilty, to have a speedy and public trial by jury on these charges?
Yes, Your Honor.
Do you understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you cannot afford your own?
Yes, Your Honor.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, Your Honor.
You understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state might have to testify against you, and you could have, you would be able to bring in your own witnesses by the use of a subpoena.
Yes, Your Honor.
You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything. And no inference of guilt would arise because you did not testify at your own trial.
Yes, Your Honor.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and a sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, Your Honor.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer worked out. You understand that? That's going to result in a number of convictions that are going to be on your record now in the future to make more severe the punishment you receive if you're ever again convicted of a crime. Do you understand that?
Yes, Your Honor.
You understand everything I've explained to you?
Yes, Your Honor.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, Your
You understand if you plead guilty, the court of the state could ask you questions about these offenses, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if it is determined that you are lying under oath.
Yes, Your Honor.
Is your decision to plead guilty today voluntary?
Yes, Your Honor.
Anybody forcing you to do this against your will?
Okay.
You understand I cannot accept these pleas unless I'm satisfied that you are in fact guilty of these charges.
Yes, sir.
And that there are facts to support it.
Yes, sir.
And I'll start with docket number 150. Let's see. 14982, which is the simple assault. You're guilty of those charges.
Yes, Your Honor.
Would it be simpler for the state to just give me a factual basis for these things?
I can't.
All right, let's do the step aside and let General McLeod tell me what the facts would be in each of these cases.
Yeah, you give it to me.
I can hear those.
Hey, Judge, if you just give me a minute to get through all these files.
We'll do that.
Starting with 14982. The first count was amended to simple assault. And the facts to support that would be that on May 29th of 2024, Corporal Miranda Lewis, an employee of the Humphreys County Jail, was given Mr. Odom a mop bucket. And when she popped open the door, he started trying to talk to her, then he came through the door at her. And when she tried to shut the door, he actually hit her in the head and her ear area and on her cheek. Going down to count 4, which is also amended to simple assault. Correctional Officer Jeffrey Smith was running a security check on June 21, 24. And he got into a discussion with Mr. Odom about a tablet. And as he was looking down to tell Mr. Odom what time it was, he threw urine at the CO through the crack of the door. In 15099, we have count 1, which is assault on a first responder E felony. And the facts to support that. Officer Michael Lansford was working at the jail on July the 24th, 2024. And when he interacted with Mr. Odom threw a cup of urine on the officer. He actually threw it on 2 officers, Karen Brooks and Michael Lansford. And that's the first 2 counts. Count 4 is aggravated assault, the C felony that occurred on July 28th of 2024 when Mr. Odom struck Correctional Officer Kara Hunt as she was passing food trays in the hallway. When she got to his cell, he threw feces on her, and then he proceeded to strike her on the left side of her face, torso, and legs. Going to count 7. Same set of facts with Correctional Officer Jacob Dooley, who's performing his duties in the jail on or about August 5th of 2024, came into contact with Mr. Odom, who threw urine on him. Count 8. The same set of facts, but on August the 10th, involving Correctional Officer Kara Hunt, who was a victim in another count. Count 9. On August the 10th again, Mr. Odom did the same thing with Officer Trenton Tummins, but I believe the facts were a little different on that one. He threw urine on him as well. And then count 9, now we're at count 10. And again, Your Honor, it's the same set of facts. On August 10th again, Mr. Odom had an interaction with Corrections Officer Aaron Burkett, and he threw urine on them. This actually, he threw urine on 3 people at once. The last 3 victims, the last 3 counts, were all the same thing. And moving forward to 15154. Count 2. This happened on June the 16th of 2025 and involved Mr. Odom and Michael Lansford again. He spit in the face of both him and CO Gabriel Cooper intentionally. And that is actually counts 2 and 3, Your Honor.
Stone, go back to the podium, please. Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Sanders has done a good job of representing you competently.
Yes, sir.
Sanders, you know of any reason you should not enter these pleas?
No, I don't, Your Honor.
Anything further from the state?
No, Your
Michael Odom and docket number 14982 upon your plea of guilty to count one, I found you guilty of misdemeanor assault, sentenced you to 11 months and 29 days in county jail, ordered to pay the court costs. Count two is dismissed. Count three, you're found guilty, sentenced to 11 months and 29 days in county jail. That would be concurrent. Count one, you're ordered to pay the court costs and have no contact with the victim, William Farrell. Count four, you're found guilty, sentenced to 11 months and 29 days to serve concurrently with count one. And docket number 15099 upon your plea to count one, you're sentenced to 1 year in the Department of Corrections, sentenced to order to pay a $10,000 fine and cost that will be served consecutively to the prior case. Count two, you're sentenced to 11 months and 29 days in the county jail that will be served concurrently with count one but consecutive to the prior case. Count three, Nolly. Count four, you're ordered to, you're found guilty of aggravated assault, sentenced to 3 years, Tennessee Department of Corrections. That will be served concurrently with count one, but consecutive to 14982. Count five is Nolly, which you're ordered to pay restitution of $590 to the Humphreys County Jail. And that will cover one mattress, one Paytel tablet, and 2 cameras. Count six is Nolly. Count seven is found guilty, sentenced to 1 year served in the Department of Corrections, ordered to pay a $10,000 fine and cost, concurrent to count one, consecutive to count to 14982. Count eight is amended to misdemeanor assault, 1129 to serve in the Department of Corrections. That will be concurrent to count one, consecutive to 14982. Count nine, you amended to misdemeanor assault, sentenced to 11 months and 29 days. That will be concurrent with count one. Count 10, you found guilty, sentenced to 1129 to serve in the county jail, concurrent to count one, consecutive to 14982. One five one five four, found guilty of vandalism. Vandalism charges. Nolly. Count two, is found guilty, sentenced to 1129 to serve in the Department of Corrections. That will be consecutive to 15099. And count three, he's been sentenced to 1 year in the Department of Corrections, ordered to pay a $10,000 fine and cost. That will be concurrent to count two, but consecutive to 15099. You know, I've been to the zoo, and one of the things they tell you at the zoo is that you don't get too close to the monkeys' cages because they tend to throw feces and urine. You might want to think about what you are saying about yourself when you do something like that. He's demanded to serve his sentences. I'm not sure that the Department of Corrections employees would be quite as understanding about that kind of conduct. You might want to think about that. That's the judgment of the court. Thank you. Is that all you have, Mr. Sanders?
Senator Angela Baker, the second called that earlier today. I've spoken with General thought about that. We have agreed to pass that until October the 6th. We're working toward a settlement, I hope.
All right, Angela Baker, October 6th.
General McLeod also filed a motion related to her a bond revocation motion, and that will be passed as well.
Motions are passed.
Thank you.
All right, Mr. Sensei, you have matters I can take up?
Yes, sir. Going down the docket, starting on page one, State versus Ethan Beard, that would be 15063, 15064, and 15065. Mr. Beard is approaching the podium. Consistent with what we discussed in chambers, Your Honor, we are going to reset Mr. Beard, the suppression motions and the motion to dismiss on Mr. Beard to August the 6th at 1 p.m. to be heard in Charlotte. And I believe we can reset the motion to sever as well, but I think we reach an agreement on that one.
All right. Any of these that you're agreeing on, you can just give it a separate agreed order.
Yes, Judge.
Yes, Judge.
All right, 1 o'clock on August the 6th. That will be in Charlotte, Tennessee, on the Justice Center and in the second floor, courtroom 5 will be where you need to appear. All right. 1 o'clock.
Thank you, Judge. The next matter going down the docket, Your Honor, would be State versus James Tyler Dabbs. That would be on page 3 of the court, 3 and 4 of the court's docket, 15113, 15114, 15115, and 15209. Judge, we're going to, similarly to Mr. Beard's case, as we discussed in chambers, we are going to reset the motion to suppress in 15114 and 15209 to August the 7th at 9 a.m. to be heard in Charlotte.
Right.
I also had a motion for a bill of particulars. I think we should be able to reach an agreement on that, and I can submit an order. Okay, so I guess we'll set that for August as well, just in case.
All right. And these will be set at 9 o'clock on August the 7th in the Charlotte, Tennessee Justice Center for Dickson County. That will be on the second floor of courtroom 5.
All right.
Thank you. What else do you have?
Next matter I have going down the docket, Your Honor, is going to be on page 4 of the court's docket, State versus Samantha Lynn Garner. That's 14049. Ms. Garner is approaching the left turn. We've reached an agreement on her case and having her sign that new petition now. Judge, Ms. Garner's here on a motion or on a community corrections violation. She's going to be admitting the violation, waiving her hearing, and then placing her sentence into effect to be served concurrent to her Dickson County sentence, and with the credits as reflected on that plea petition.
Ms. Garner, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall give is the whole truth and nothing but the truth, so help you God? I do.
State your full name for the record.
Lynn Garner.
Ms. Garner, you're here today on a violation of community corrections. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had actually violated your probation?
Yes.
Do you understand you would have the right to have a lawyer and have one appointed as you, if you could not afford your own? And of course, we've done that with the public defender.
Yes.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
You understand that by pleading guilty and waiving your right to that hearing, to that appeal, all I'm going to do is revoke you to serve your sentence, and that will be concurrent with your Dickson County sentence with all of your credits for time served set forth on this document. You understand everything I've explained to you? You want to plead guilty according to that understanding. Then I find you guilty of violating your probation order that you be revoked to serve your sentence, that will be served concurrently with your Dickson County sentence, and all of these times that you're entitled to credit are set forth on this document. Thank you.
Proceeding down the docket, Your Honor, what's ready? The next matter that I'll have is on page 5 of the court's docket. That would be State versus Hannah, 15240. Mr. Hannah is approaching the lectern, Your Honor. This is before the court today on my motion to reduce bond. We have reached an agreement on that case by which Mr. Hannah's bail amount will be reduced to $1,000. And it will be on condition that he continue reporting to his community corrections officer and following any lawful orders that she may give him.
All right, I'll sign your agreed order. Thank you. Is he set for a status or?
He's set for status on October 6th, Your Honor, I believe. All right, Judge, continuing on down, next matter I've got on the court's docket is going to be on page 6 of the court's docket, State versus Byron Notorious Jones. Mr. Jones is approaching the lectern. He's before the court on a motion or on a violation of probation. and I'm tendering a plea petition that has been signed by all parties, by which Mr. Jones would be admitting his violation, waiving a hearing, placing his sentence into effect, concurrent to any other sentences that he's serving, and with credit for the time served as reflected on the plea petition.
Mr. Jones, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony that you shall now give is the whole truth and nothing but the truth, so help you God?
State your full name for the record. Mr. Jones, you're here today on a violation of probation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation? You understand you would have the right to have a lawyer, to have one appointed, as I've done with the public defender. You understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea, you're waiving your right to that hearing, to that appeal. All I'm going to do is order that you be revoked to serve the sentence, the balance of your sentence, but that would be concurrently with any other sentences you might have. And you also get credit for all your time. You understand everything I've explained to you? You want to plead guilty according to that understanding. And upon your plea of guilty, I found you guilty, or that you be revoked to serve the balance of your sentence concurrently with any other sentence you might have, and you'll get credit for the times as set forth that you've served, set forth on this document. Thank you.
Your Honor, the next matter that I have before the court is going to be on page 6, continuing to page 7. That's going to be State versus Shonda Lombardo, 15120, 15121, 15148, and then 15184 and 15223, as well as another case that's going to be before the court without a docket number on a criminal information. I am passing forward and double checking. Case judge and having her sign petition. Okay. A little bit going on here, Judge. You just bear with me. Take them all in order.
All right.
Okay, so in case 15120, Mr. Lombardo will be entering a no contest plea to theft between $2,500 and $10,000, a Class D felony, for which she would receive a sentence of 3 years in TDOC custody, suspended supervised probation with time served credit. As reflected on the plea petition, she would be ordered to pay costs and must pass all drug screens with zero tolerance for failed drug screens. As a condition of probation, she would be ordered to have no contact with Emerald or James Bruce. And there would need to be a restitution hearing set at some point. And then 15223, 15148 would be dismissed. In settlement, she would be sentenced as a range 1 offender. In 15121, Ms. Lombardo would be entering a no contest or a no contendere plea to possession of unlawful drug paraphernalia, for which she would receive a sentence of 11 months and 29 days concurrent to 15120, suspended to supervised probation with time served credit, and she would be assessed a $150 fine plus court costs. And counts 1, 2, and 4 would be dismissed in settlement, along with the other docket numbers that I previously mentioned being dismissed or not in settlement. She would be, if she were revoked to serve, she would be ordered to serve 75% of her sentence. In 15184, and of course, as reflected, 15148 and 15223 would be nollie. There's plea petition to that effect. In 15184, Ms. Lombardo would be entering a no contendere plea to count 1 simple possession of marijuana, a Class A misdemeanor. She would receive a sentence of 11 months and 29 days, suspended supervised probation, concurrent to 15120. She would receive credit for time served. She would be assessed a $250 fine plus costs. And as a condition of her probation, she would be ordered to pass all drug screens with zero tolerance. She would again, in that case, be ordered 75% release eligibility, were she to be revoked to serve. And even though I said time served credit, I don't believe that there's any on that case as reflected on the plea petition due to it being a citation. Then in this new case, the court will observe that there's criminal information that's been signed by everybody, by which Ms. Lombardo would be charged with forgery, a Class D felony. She would waive her right to have the grand jury indict her and would want to proceed upon a plea for that. And that plea would be for her to enter a nolo contendere plea to forgery, a Class D felony, where she would receive a sentence of 1 year in TDOC custody, suspended to supervised probation, consecutive to 15120 with credit for time served. As reflected on the plea petition, she would be ordered to pay costs, and as a condition of probation, she would be ordered to pass all drug screens with zero tolerance for failures. And she would also be sentenced as a range 1 offender in that case. So overall, it's a 3-year sentence.
Lombardo, raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the testimony you shall give in this case is the whole truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record.
Lombardo.
Mr. Lombardo, you've heard your lawyer go over all of the charges that you have, what the agreement is on all the charges, but have you seen or been shown a copy of the charges against you and talk them over with Mr. Sensing and discuss with him the range of punishment you're facing as well as any possible defenses you might have? Well, it's indicated that you want to enter a plea of no contest. All that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. When the state tells me what their evidence is and that they would use at trial, that evidence will be used by me to find you guilty according to this agreement. You understand that? You understand that you have a right to plead not guilty and to have a speedy and public trial on all of these charges in this court. You understand that trial, you would have the right to have a lawyer and have one appointed as we've done with the public defender. You understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and Mr. Sensing could confront and cross-examine every witness the state called to testify against you, and you could bring in favorable witnesses of your choice by using a subpoena. You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. If you went to trial and you were found guilty, you would have the right to appeal that conviction and the sentence imposed. Do you understand that? You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out for the state. You understand that's going to result in a number of convictions, and those convictions will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand everything I've explained to you? You want to waive your right to a trial and to an appeal by entering a plea of no contest. Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will? You understand that I cannot accept your plea unless I'm satisfied that you are guilty and there are facts to support it. Then I want you to step aside and let the state come to the podium and tell me what evidence their case would be, what evidence they would have at trial.
Ms. Judge, if this case had gone to trial, the state would expect to be able to show that in case number 15120, between May the 1st and May the 2nd of 2025, Ms. Lombardo here in Humphreys County did take a vehicle not belonging to her. She got in the vehicle and she did drive it around for a while, but she left it in a field. So she didn't keep it, but she did take it for a while. And left it not with the owners. And 15121, count 3, possession of drug paraphernalia. On June 15 of 2025, the state would expect to be able to show that Officer Corey Field of the Waverly Police Department made contact with Ms. Lombardo here in Waverly, and she consented to a search of the vehicle. The odor of marijuana was coming from the vehicle, and during the search, the officer located 2 packs of rolling papers and a roach with a little bit of marijuana. 15148 is Ben Nolly. 15184 is a simple possession of marijuana case. On that one, the state would expect to be able to show that on August 20th of 2025, Sergeant Sean Gary with the Humphreys County Sheriff's Office made contact with Ms. Lombardo. Her driver's license was suspended. He stopped her, made contact with her, and she gave up a bag of marijuana that weighed about 3 grams during the stop. And another bag of about 2 grams was also found. 15223 is also being nollied, which brings us to the forgery case, which is the criminal information. And the facts of that one are that on or about April 10th, 2026, Ms. Lombardo used a check belonging to a Mr. Jerry Gregory to complete a purchase without his consent. The items that were purchased totaled $130.09. And the checkbook that contained that check was stolen from his vehicle at an earlier date. Now, I did want to ask if Mr. Sentencing agrees to set it for a sentencing hearing. Or not a sentencing hearing, a restitution.
Restitution.
Sure. I mean, I guess maybe a status, we may be able to reach an agreement. I think that if we were to set it for a restitution here, it would trigger a pre-sentence report.
If it's restitution, I'll have to order a pre-sentence report. So
Status is fine. That would apply to the theft and the forgery.
I have to set it for
Sure.
status on October the 6th, and then if you can't reach an agreement, we'll have to order a pre-sentence report.
Yes, Judge, and that is case numbers 15120, and in the forgery, it's the basis of the criminal information. I have to confirm if restitution is in fact owed on that one.
Ms. Lombardo, if you'll come back, I failed to go over with you about your criminal information. I want to make sure you understand what you're doing in that case. I know Mr. Simpson is a very good lawyer and has explained it all to you, but every person who is in charge of a crime that possibly carries incarceration carries with it the right to have a grand jury of the county in which that is alleged to have occurred to review the evidence. The grand jury is an independent body. They operate, they hear one side of a case, but they make a determination whether or not there is probable cause to even return a charge. You have the right to waive that step to expedite the disposition of your case, which is what you're doing here. But you also have the right to demand that the grand jury review your charges to determine whether or not there's even enough evidence to go forward. Do you understand that by entering this criminal information, you're waiving or bypassing that step of the grand jury? And that's what you wish to do to expedite the disposition. Right. Do you understand that the evidence that the state has told me their evidence would be at trial is what I'm going to use to support your finding you guilty of these charges? Are you satisfied with your attorney services? You feel like Mr. Sensing's done a good job of representing you confidently? Mr. Sensing, you know of any reasons you should not enter these pleas?
I do not.
Anything further from the state?
No.
Then Shonda M. Lombardo in docket number 15120, upon your plea of no contest to count 1, I find you guilty, sentence you to 3 years Tennessee Department of Corrections. And will be suspended to supervised probation with credit for time served in order to pay the court costs. As a condition of your probation, you must pass all drug screens with 0 tolerance. That means 1 positive drug screen, and you will go to prison for that time. You're to have no contact with Emerald and James Bruce. We will set a status rather than order a restitution hearing at this time. Docket number 15223 and 15148 are both dismissed as a part of the agreement. 15121, you're found guilty of unlawful drug paraphernalia, sentenced to 11 months, 29 days in the county jail. That will be concurrent to the prior case. In order to pay a $150 fine, you will be suspended to supervised probation. In order to pay a $150 fine and cost. 15184, you're found guilty of simple possession of marijuana. Ordered to be sentenced to 11 months and 29 days in county jail. Suspended to supervised probation, concurrent to 15120. Credit for time served, $250 fine and cost. Again, you must pass all your drug screens with 0 tolerance. 15148 and 15223 are both dismissed as I stated. And in the criminal information case, you are found guilty of forgery and sentenced to 1 year in Tennessee Department of Corrections, suspended to supervised probation. That will be consecutive to 15148 120. This will mean that you have an effective 4-year sentence, 4-year probation. You're ordered to pay the court costs. And again, as a condition of your probation, you must pass all your drug screens with 0 tolerance. Good luck to you.
All right, Judge. The next matter I have is on page 8 of the court's docket. That's going to be State versus Michael Dean Marler, 15046 and 15271. Judge, I think in speaking with my colleague, Mr. Cooper, I think there may be settlement offer pending. I was going to reset this for status in October, Judge, but could we just set this for status on the July VOP date, just so that way if there is something that we can work out, we can get.
July 28th is, I believe, that date.
Thank you, Judge. If that's agreed with the staff. I think
General McLeod, are you agreeable to resetting Michael Dean Marler for July 28th for a possible disposition?
That's fine.
Thank you, Your Honor. All right, Judge. All right. Last but not least, I want to say last but not least, if I'm sure. I think last but not least, on page 10 of the court's docket, Judge, State versus Rodney W. Priest, Rodney Wayne Priest, 15156 and 15273. Mr. Priest, approaching the podium. We've worked out an agreement on his VOP in 15156. I think he's going to sign a fee petition right now. So in 15156, I'm tendering a plea petition by which Mr. Priest would be, he would admit his violation, waive the hearing, and then be reinstated to probation on time served, revoked and then reinstated to probation on time served with the condition that he attend long-term rehab as approved by his probation officer. And then in 15273, I think we should just reset that first status in October to get through discovery and settlement conditions.
Mr. Priest, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony in this case shall be the whole truth and nothing but the truth?
Yes, ma'am.
State your full name for the record.
Rodney Wayne Priest.
Mr. Priest, you are here today charged with violation of your probation. You understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation.
Yes, sir.
You understand if we had that hearing, you would have the right to have a lawyer, to have one appointed, as I've done with a public defender.
Sir.
You understand if we had the hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty and waiving your right to that hearing, to that appeal, all I'm going to do is reinstate you on time served with the condition that you complete a long-term rehabilitation.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
You want to waive your right to a hearing and enter a plea of guilty according to that understanding.
Yes, sir.
And upon your plea of guilty, I find you guilty of violating your probation, order that you be revoked to serve your sentence, but on credit for time served and by agreement with the state, we'll reinstate you to, with the additional condition that you complete a long-term rehabilitation. Good luck to you.
Judge,
In this other case,
yeah, if we could reset that to October, and then I think the state would want to add that Mr. Priest would, within 30 days of today, need to show a good faith effort in applying that to a rehab.
this long-term rehabilitation is going to have to be, we're going to have some sort of certainty that you're going to go into it. So you need to do that, enroll in that within 30
I've already applied.
Okay. As long as you enroll in it within 30 days, we'll have that as condition. His new case is going to be reset then for the 6th of October.
I believe that's all the cases that I have, Judge.
Ms. Lowe, you have a matter that I can pick up?
Jennifer Smith, Hornick, I think, has an additional case.
Yes, sir.
I believe it was.
All right, on the Smith is a motion to revoke bond, is that correct?
Yes, sir, Your Honor.
And I have how long do you think it'll take? I've got a courthouse security meeting that I'm required as, I think I'm one of the chairman of that for the Dickson County Justice Center. We are having a hearing at noon. I'm going to come in on Zoom with that because I'm here. But
It won't take 25 minutes.
all right, then we'll take it up. Dave versus Jennifer Renee Smith.
This flow may have.
Is there anything else besides this case?
I believe there's Jake Locker's cases are still in the docket, Your Honor. He had sent a text to me and a couple other people, but he said he has a hearing at 11:30 and a plea, and then he was going to head this way. I told him, but he sent it earlier when we had to reset his cases. He was filing, but he was stuck there. So I told him I would inform the court.
All right, then we're taking up the State versus Jennifer Renee Smith.
Yes, sir, Your Honor.
This is a motion to revoke bond.
Yes, Your Honor. Low get situated, Your Honor. I don't know if Ms. Smith and Ms. Logan want to stand at the podium. I don't have any witnesses, Judge. It's going to be argument.
Let me see the picture.
Judge, have you seen the motion?
All right.
But Judge, Ms. Smith has 3 cases up here in circuit court. Make sure I think I had a misprint on one of the docket numbers. I'll make sure I get them right. I started to double check it. Docket number 15228, 15275, and 15206. I think actually 15275 was for arraignment, and we reset it. So I don't know that she's been arraigned on that one, Judge. So I don't know.
I don't think she has been.
Want to do that first?
Just a rainer on that. I'm going to hand a copy to Ms. Lowe, a copy of that indictment.
Plea of not guilty.
Plea of not guilty is entered. We need to set it for status for July 28th. Well, and only because the co-defendant Eddie Roney is set for status on that July 28th date, so we'll just set it for that date as well.
So Judge, Ms. Smith was arrested in Humphreys County General, and some of this is for clarification. I talked to Ms. Lowe about this. She was arrested on October the 5th in General Sessions Court for felony possession of methamphetamine, felony possession of fentanyl, simple possession of drug paraphernalia, reckless endangerment, driving and possession of methamphetamine, and driving on a revoked or suspended license. That was bound over and is currently docket number 15228. She posted an appearance bond on that case of $34,000 on October the 5th. While she was on bond for that, Judge, she was arrested and charged in Sessions Court in docket number, on December the 12th for felony possession of methamphetamine, possession of drug paraphernalia, and those cases have been bound over to the grand jury, and she was indicted. That's now docket number 15206, which she has previously been arraigned on. On December the 18th, Ann Blankenship Bonding, who made her bond in what is now docket number 15228, came off of her bond, and she was surrendered to the Humphreys County Sheriff's Office. Don't know what happened. I think there was a paperwork miscommunication. She made bond of $37,000 on the 15206, even though she had been surrendered in 228. She did not post that bond. So she was released on the $37,000. So while on bond in 15206 and inadvertently released in 15228, she was indicted in June this month in docket number 15275, which she was just indicted for and arraigned. And a copy is in the file, Your Honor, for the actual sale of methamphetamine. She has a bond on that, so the state was just asking that she be revoked, Your Honor. And clarified on that one that she didn't actually make bond. She revoked it on that, I'm sorry. Put it misspoke.
Judge Smith's position in this is just that she has continued to report to court regardless of where she was. She was in rehab. She always made arrangements to be here. She has never been a flight risk. She's just asking that the bond stay in place. And in the event that she's able to make bond, she can have a bond source hearing to show the source of those funds.
Lloyd,
That's all.
state has rested their proof. Do you want to offer any proof?
No, Your Honor.
Well, the statute makes it very clear that anyone who has made bond during a time that they were have charges pending against them, and while they are released on bond or charged with, it doesn't require conviction. It's just that they are charged with a new offense, then the court has the ability to revoke that bond and to hold them for trial without bond. In this particular case, she's already been surrendered by one of her prior bonding companies, having been exonerated, and released from the bond. So it appears to me that there's ample reason for this court to find under that statute that Ms. Smith should be held without bond pending the trial. So order that she be held without, the motion to revoke bond is granted, she'll be held pending the trial. Do we have a trial date or a status date that we need?
Just that July 28th, Judge.
July 28th on the status. That'll be the judgment of the court.
Thank you, Judge.
Thank you. So that concludes all of the cases that I have except for Mr. Locker.
I believe so, Your Honor.
And right now, we don't really have any expectation or knowledge as to when he would be here.
Well, he just sent another one. He said the state had a witness problem. The hearing's now set at 12:30. So,
Right.
But Judge, all I know that he's got is general foul, but Mr. Burns is just for status. He did file a motion, but just filed it yesterday. And then
I think
Mr.
I think that was where his bond was revoked last week and it was sent back for status.
Yeah.
Yeah.
And Mr. Locker did.
All of Mr. Locker's cases will be set for status on July 28th.
Sir.
On Brewer, will you have to?
I think he has to hear that.
Yeah, we're doing.
You tried that, Judge, I think.
You revoked his bond, right?
On Brewer, then that case will be set in front of me, and we'll have to do it obviously on 10/6, October 6th.
I know that that's just a status. This is just one.
So I'll text him, so Mr. Brewer, what was the date? I apologize. 10/28.
Well, I said October the 6th, but
Oh, I'm sorry.
And then July 28th, Mr.
July 28th for his other
Scott
case.
Burns.
All right, then that concludes our business. We stand adjourned.
All right.
I had posed some calls that I would pay on these two, and there's something else. I don't know. Hang on, let me go over Stephanie. No, I have concerns like with
On the
these two,
14th.
the 14th, and just the Wi-Fi.
Yeah, I just saw that as well.
I guess I should have
It's gonna be a 14.
Yes, four. On 206,
Either.
You pick. I mean,
Well,
I'll be
she
here.
has a co-defendant in
Brownie,
one,
he's on the 28th.
well, she has a co-defendant in 15206, Timothy Call,
Right.
and he's on 714.
Whatever day.
So-
Stephanie's on that.
Okay. Okay.
Oh, here.
I'll be here both days.
It looks like I will.
Okay.
Oh, yes, I will.
We can keep it there, it's good, and it's good. I'll be here.
For 714.
Thank you.
Yes, ma'am.
Stressing me out.
Right. When you hire you. You will.
And she was a long haul truck. Driving a truck that had no load.
Dickson?
Yes. Are you on it? Or no? I think that's it.
Oh, Angie, I've got more.
He was connected.
Angie, I have more.
With,
Why do you have a PD? Not that.
I don't know.
I'm sorry.
I don't know. All I know is when.
I think Myron Jones was 11. Okay.
And I was like, okay.
So I was gonna go back and look. Because when you see it, they don't show you, you know. Well, I need to fix it.
Oh, I'm not.
He was out for, and then I guess like someone hostage, grease on their balls. Yeah.
All right.
Sounds like he's good at talking trash.
I don't know what he is.
What's going on now? Stephanie, I don't want Stephanie like finding her body.
He has, but
He can't.
I, that's a crap. All that was put out. I'm trying to see if that was something that we even discussed with him. Because what we.
They called you.
Are they looking for a call?
I don't know. They contacted me on the 23rd and I was like, I
You
don't know
don't
where
need
I'm
anything
at.
from them.
And I said,
So it's like,
they're
not,
not,
but they're going and saying that. And all of our judges were on board after everything was explained. And I was like, I don't think so.
Really freaked out. Or he'll be more freaked out than you. He'll think you're coming from both. of them.
Like,
name on the side.
No, I'm guilty
it's a
about
hot
this.
mess, Chris.
Yes, that's correct.
Hey, Grace, how you doing?
Yeah, don't do that. And also, this. It's just completely.
Most of it.
Preferably, yes. One that I can pick up that's. I don't know why I feel rushed or anything like that. And just like.
Come back from.
If you're gonna allow it.
I'm doing Gimpy's work over there for thank you.
I appreciate y'all. Thank you. They just couldn't find anybody to represent you. So, here.
Do you have any?
The rest of.
Thoughts
I don't know. I email and so my guess is there's.
Okay.
But VOP.
Well, yeah, I was just gonna go down. and-
Basically, we're.
It wasn't just something he
Like,
can
what
use
is
again.
that even entail? I don't know how to.
Cameron's going to live here too.
Well, if you remember, if you just wanna shoot me
What's
an
he got?
email on what you want out of the new case, just find you guys, I'll go down.
What's he got?
I'll help you reach the conclusion that it needs to
The death penalty helps.
Huh?
Is your mama down all week?
Well, we agree, like, all he's got is domestic.
Did you need her?
So.
No, I just need.
That runs the current bill.
Yeah. Good deal. Might even be tomorrow, I don't know.
I can't tell you what Tamage.
I know, but.
Tamage wants some money.
Sorry. I don't know what he's got.
Does it work?
I'm well aware already.
It's zero redeeming quality.
be in court Monday? He is not.
He'll be in Washington. with me.
That's what I was wondering. If he's gone with you, because I've got someone that I put today, Gregory, and I sent him an email on it. Who's covering it? You know? Yeah.
I got a lot going on.
I don't remember asking that snows.
Are they gonna, is Monday when we're off for July 4th?
No, we're all Friday. On Monday, we have.
Yeah. Leaving tomorrow, I'll be back on the 9th. My flight gets in late, so I'll probably.
Okay, thank you. Used to be,
Except for she didn't get to say.
That's okay.
Then I need to cover, no, once they're not. Besides, the guy that I sent up there, I need to. But then you said,
I'll-
no, Collins got
I
sacked.
gotta get,
I can come down there and grab it right now.
Okay.
Oh.
we're working through lunch.
Good job.
I'm always taking.
I couldn't-
What did you do wrong? Not one thing we.
I couldn't, say it.
We all.
Sorry.
Nothing trying to celebrate.
So you going to the prison farm?
What?
Are you going to prison farm?
Yes.
I'm stalling. Is it the first?
What?
You're going to
Me and Liz both go in to visit.
I'm sorry.
Brady.
Great.
That's why I gotta go talk to him about the Anthony Brady.
I don't know if I'm even at my meeting. I see him there in front of my box. I thought I had that today because sleep on it all. Stipulation, so I start pouring fine. He's back at it.
They, this happened, the murder was done at the county. And they notified us. I don't know when they do, but it was there.